Hi everyone, this is attorney Lillian with Lily Legal, where I help my clients get immigration status and reunify with their families using the U.S. immigration system. So today I have some amazing things to talk to you about. I know for the past 4 years, every time I come on here, it might have seemed like I was giving you another bad news or something, but today I have some great news for you. Some amazing news. Guys, I'm very excited about the changes that have already happened under this new administration. And I am basically going to go through what the changes are already and what we should be expecting for the future. There's so much. So, one thing I wanted to cover that happened last year in December, actually, is for the librarians in the group. Okay, this is the Liberian Green Card Act that I talk a lot about on my page. Basically, last year, if you guys remember, I said that there was a deadline, and the deadline was December 20th, 2020. Well, that deadline has changed. So Congress passed, basically recertified the act and and added one more year. So if you qualified under the Liberian Refugee Immigration Fairness Act, which basically gives Liberian nationals that have been in the U.S. since February I'm sorry, since 2014, November 2014. If you have been in the US, physically in the US since November 2014, and you meet all the other requirements, you can get a green card right here in the US. You do not have to leave the US in order to qualify. This applies to you even if you came into the US without documentation. That's how great this act is. So if you missed the chance to apply last year, well, you get one more year, okay? So don't wait. Apply as soon as possible because, again, this is one of the best things out there for Liberian nationals, and you should be taking advantage of it, okay? So now let's get into what has happened in the last 24 hours because there's so many great things that happened in 24 hours that I can't wait to share with you guys. So the travel ban, if many of you remember, under the last administration, there was a travel ban that basically, also known as the Muslim travel ban, that stopped people from certain countries from being able to file immigrant visas to come to the US. So if someone is in the US and they're a US citizen and their spouse or their children are in these countries, they are not able to file for them unless they qualify for a waiver that's up to the officer. There was no standard. Now, those are gone. Okay, no more waivers, no more ban for these countries. So I know a lot of my Nigerians are going to be very happy with this because this basically makes it possible for you as a US citizen to file for a family member, to file for your husband, your wife, your children, your parents in Nigeria, in Libya, in all these different countries. So it is really important if if you were previously under this travel ban to know that you are no longer subject to it. So if you were holding off filing for family members, because of the travel ban, you can now go ahead and file. And this is kind of something I told you guys last year when people would ask me, should I even start the process if there's a travel ban in place? And I said, well, you can start the process. The process might not get to finish because of the travel ban. You might have to wait for the travel ban to be lifted. Well, for those that did listen to me and did start the process, now your application is just going to continue. You're going to have the interview, and your case can be approved. If you didn't listen to me, it's not too late. Go ahead and file right now. It is not too late to file for your family outside of the US, okay? So that is one of the great things that happened as of yesterday. Another great thing, which is something that I will have to explain to you guys a little bit, but it's basically called prosecutorial discretion. And this is back. And this is a great thing. And I will tell you why this is a great thing that it came back. So this means, so basically the government has the decision of who to put in immigration court, who to fight to deport, who to give a green card to. So with this in place, the government has more discretion. So they will be able to say, well, you don't have a criminal record. We don't have to pursue trying to get you out of the country. Before, like last week, if you, let's say you file for a green card and it turned out you didn't qualify for the green card and you get denied, the officer that denies your application has the option to basically put you in immigration court. But with this new prosecutorial discretion, it means that unless you fit into certain categories, like you have an aggravated felony conviction, you just came into the US, you have previous orders, there has to be something in your record. You're a terrorist or you're suspected of being a terrorist. So if you fit into those categories, they can put you in immigration court and fight to get you out of the country. If you do not fit into those categories, they should not put you in immigration court. So that's why this is great, because I have seen over the past 4 years that if someone files for a green card and gets denied, the chances of them being put in immigration court just because they were denied and they don't have another status to fall back on was very, very high. Now, that is no longer the case. The officers that are interviewing you for your green card application has less power now to put you in immigration court, unless, of course, you fall under the terrorism, aggravated felony categories. So again, this is great news for you, because I had a lot of people that were scared to even file because they're afraid if they get denied, they will be put in immigration court right away. Now this is back. It's going to be less likely that someone that doesn't have a criminal record, that has been in the US for, let's say, 5-10 years, that someone that doesn't have any affiliations with terrorist groups would immediately be put in immigration court proceedings and try to be removed from the US. That's going to be less likely. Okay. Now, the next thing, which is one of the more exciting things that happened, is deportations are on hold for at least the next 100 days. So this means if you have went through immigration court and the judge found you to be deportable, this right here would mean that you get to stay in the US. Does that make sense? So for 100 days, US government cannot physically put someone on a plane and have them leave the US, even if they have a final order of deportation. So it is very important to basically know that this is in place, and make sure you're checking in with your, if you had a lawyer that worked with you through the deportation proceedings, make sure you're following up with them on this, and make sure if you have any questions, right, on whether you fall under this or not, feel free to reach out to my office, and I will be more than happy to look through your case and see what you qualify for, and what and how any of these things that are coming out can actually help you. So those are the things that are immediate. Those are the things that are already in place. So the first one is that the travel ban is gone, right? Liberians get another year to file for a green card. And US government will not deport anyone for at least the next 100 days. And finally, prosecutorial discretion, less people are going to be put in immigration court to be removed from the US. So those are immediate. Those are already in place as of today, okay? Now, the next things I'm going to talk about will require Congress to act. Okay, so I have a question that I'm going to answer just because it goes with what I just talked about. So the question is, if a person is guilty of a crime, though that person has a green card, can that person be deported? Well, the answer to this is the classic lawyer answer. It depends. It depends on what the crime is. It depends on how long the person has had their green card. It depends on how long the person has been in the US. Okay, so those three things will need to be known in order to basically know and what the crime is. So 4 things: how long you've had your green card, what the crime is, how long you've physically been in the US. Those are really what you need to know. And if the person, so it said, is guilty of a crime. So I'm guessing they already went through court and they were found guilty. I'm guessing that's what this is about. So it really depends heavily on what the crime is, how long the person has been in the US, how long the person has had their green card. That's what it depends on. Okay, so if you would like for me to actually go through whoever that is, their case, and figure out if it would affect their green card, if they are subject to deportation. Okay, so just because you're found guilty of a crime as a green card holder doesn't mean that you're automatically going to be removed from the US. It heavily depends on the crime and your time in the US. Okay, so definitely reach out and schedule a consultation with my office, because I would need to, typically for a criminal record, I would need to see the certified docket sheet from the court that found the person guilty of whatever crime it is, because that way I can look and make sure that the crime actually is something that you can be deported for. Something that might be an aggravated felony in state court might not be for federal purposes. So it's really important that you reach out and have those documentations ready for a consultation, so that I can actually look through them and see if this could disqualify you or lead to you being found removable from the US. Okay. So I'm going to go to the next things that that are coming up that I'm very excited about, and that you should be very excited about, and that you and I need to hold the administration accountable for. Okay, so it's really important that we don't let up. Yes, we got a good administration that's passing good immigration policy, but now we need them to go further and make new immigration laws that benefit you and other people out there in the US and outside of the US. I want to immigrate to the US. So they have already started working. Like I said, besides the stuff that I already talked about, they have already sent a bill to Congress for immigration reform. This is great. Okay. One of the things that I'm very excited about is that it creates a path to citizenship for undocumented individuals. So this is not limited to people with TPS. It's not limited to people with DACA, right? The way their bill is structured is basically for anyone that's in the US that's undocumented as of January 1st, 2021. That's how it's structured. That's what the bill is basically, those are the people the bill is looking to benefit and will give a path to citizenship too. So based on what we know so far of the bill, it's going to make it possible for someone that's undocumented in the US to get temporary status. That means you can work. That means you are free from fear of ICE, of anything like of interacting with the police, because it might lead to you being in immigration court. You're free from that. So what does that actually look like? So right now it looks like they're looking at temporary status for 5 years. If you can show that for 5 years you can be a good citizen, right? That no criminal records, nothing of those sorts, then you can apply for a green card. And as you guys know, if you have your green card for 5 years, you can apply for citizenship. Okay, so that's the path that is laid out right now in the bill. The next one is for people that already have TPS or have DACA or had DED. Those people will be able to basically skip the 5 years and be able to apply for a green card. Okay, so that's, to me, that's very exciting, because you'll basically go from having a temporary status like TPS or temporary status like DACA and be able to apply for a green card, because you've had those status for several years and you have shown for those years that you didn't have a criminal record, and that you have been basically living in the US and following the rules. So now you get to apply for a green card, while someone that has never had TPS, never had DACA, will be able to apply for temporary status, show that they can meet those requirements of not having a criminal history in that 5 years, and be able to apply for a green card, and then 5 years from then be able to apply for citizenship. Okay, so this is a path to citizenship. It is not temporary status. It is not, something that goes into effect and then the next administration will just pull it out from under you. This is a bill that will become law. At least that's what we're hopeful for, that Congress will do their part and make this a law, so that people can stop being in fear, and people can actually start being productive members of the US society by being able to work, being able to become citizens, have their family with them as a unit here. So that's what we're looking at, and hopefully that happens. Farida is asking, does this apply to those out of status on F1? So we don't, like I said before, we don't know the full details of the bill. However, if it does apply to people that are undocumented, so I would assume if the person is not in status right now as an F1, that basically means you are quote unquote undocumented. So that person would fit in under this once we get more details on who can actually apply for it. Right now, it seems that it's just for any undocumented person, and it doesn't put a limit on who that person can be, other than that the person had to have been in the US as of January 1st, 2021. That's really the limitation that there is on that right now. So if you're already in the US as of January 1st, 2021, the way the bill is structured is that it would apply to you if you do not currently have status in the US. Okay, I hope that answers your question. So that's the first thing that I'm very excited about on this new bill. The next one is that they want to eliminate the 3 and 10-year bars. And this is major. For anyone that knows immigration law, if you are in the US and you are out of status, let's say you're out of status for 6 months, and then you leave the US, you are banned from applying to come to the US for 3 years. If you're in the US out of status for a year or more, you are banned for 10 years if you leave the US. You cannot apply for a visiting visa. Your family that's in the US, even if they're US citizens, they can file for you, but you won't be able to get a visa to the US because you are banned for 10 years or 3 years, depending on how long you overstayed. If this goes away, so this is important for people if you're in the US, right? So let's say Ben, right? Let's use Ben as an example. Ben is in the US. He came in with a visiting visa in 2010. He never left. He met his wife in 2018. They got married. They have a kid. And now Ben's wife, that's a US citizen, wants to file for Ben. Well, she can, because Ben came in with a visa and he's not subject to the 3 and 10-year bars because he never left the US. Now, let's say that Ben's wife is a permanent resident, right? She's not a citizen yet. That means Ben cannot apply to become a green card holder in the US. He will have to leave the US to his home country's embassy to go to the interview and come back. You see how that would be a problem? Because I already said Ben overstayed since 2010. So if Ben leaves without a waiver, without anything, and just gets up and leaves to go to the interview, now he's banned for 10 years. He can, even though his wife filed for him, there's an interview date, he goes to the interview, they can't approve him because he's banned for 10 years. And now they have to apply for a waiver and all these things before he can come back. If this bill actually passes and it actually eliminates these bars, that means that if you have overstayed your visa and you've overstayed your visa for 10 years, you're not married to a permanent resident, you have to leave the US for your interview, that means you will not need to wait 10 years before you can apply for the visa at the embassy, or before you can qualify for the visa at the embassy. That is a huge, huge deal, because there are people here that qualify for a visa, but they cannot leave because they don't qualify for a waiver. So it is such a big deal that we know that this thing can actually make a difference in people's lives. So if you came to the US, you overstayed, and your sibling filed for you, now the visa is available and they're telling you, oh, you have to go to your interview. Well, you can't go to an interview unless you can apply for a waiver because you overstayed, and now the 10-year bar applies to you, right? So it's really important that we know that these things are out there and how it can apply. So Stryker is asking, what about those that have already been issued removal notices? If you bring your child to the US, you never put your child on your DV program and you put in for citizenship. Okay. I'm just gonna answer the first part because I'm not quite sure how the second part, if the second part applies to the first part. Okay, so what about those that have already been issued removal notices? So I'm guessing he is talking about people that have a notice to appear for immigration court, um, and not someone that's already went through the whole immigration court system and has been ordered to be removed from the US. So I'm guessing that's the process that he's talking about. So if the person is already issued a notice to appear, with the new prosecutorial discretion, there are things that can be done. So this is where this applies, is there are things that can be done with the government to try and get the person, either get the person's case terminated or closed so that the person can just live in the US. But again, there's always a chance that they can put someone back in immigration court. But if your case is administratively closed and you have someone that can file for you, you can then be able to still get status. And then for the second part, if you bring your child to the US and you never put your child on your DV program and you put in for citizenship. So again, I'm not sure what the question is on the second part. So if you want to clarify, Stryker, please feel free to do so. Okay, let's see. Nana is asking, if you come in with a visa and overstayed for 10 years, do you qualify for applying for a green card? So as of right now, the answer is it depends on how you want to get the green card. So if you're talking about the new bill that I was talking about, creating a road to citizenship for someone that is undocumented, then yes, it would seem that once that bill is passed, it would lead to someone in this situation being able to apply for a green card in the US. But first, they would have to get the temporary status for 5 years. And then if they can show no criminal history and they have followed the US rules for 5 years, then they can apply for a green card. And then 5 years from then, they can apply for citizenship. But if the person, let's say the person wants to apply, is married to a US citizen, they are able to apply right now without needing the bill. So if a person overstays their visa for 10 years and they're married to a US citizen, do they qualify for a green card? Yes, they can apply as long as they meet all the requirements and don't have any aggravated felonies. That's So I hope that answers the question, and I think it did. So that's great. Um, so yeah, that's what I really have for you guys today. If you have any other questions, please feel free to put it in the comments and I will be happy to answer. Does that mean, okay, so Farida's asking with the temporary status. So again, we do not know the full detail of this yet because it still has to go through Congress. However, we can use what has been done in the past as a way of predicting what's going to happen in the future. So in the past, for someone, let's say if they had TPS or they had DACA, which are temporary status, they have been able to apply for work authorization. So that's the work permit. So I would assume that if the US government expects you to freely live in the US in temporary status for 5 years, they will give you the ability to actually support yourself for those 5 years, which would be the work permit. So my guess is that if the bill passes and this temporary status becomes a thing, it will lead to people being able to get a work permit and at least work for that 5 years before being able to apply for a green card. Because once you apply for a green card, that becomes your work permit. Okay. All right. So, any other questions before I go? Actually, before I do a quick recap of what has happened in the past few days. Actually, today's only the first full day of this current administration, and so much has happened already. So, okay, questions. Okay, you're welcome, Farida. Happy always to answer your questions. All right. So I'm just going to go through the headlines, right? First, librarians. The Green Card Act is back, and you have until December 2021 to apply. Please don't delay, because I know some people missed the deadline of December 20th, 2020. So you get a whole year to apply. So please do not delay. And if you need help with the application process, please feel free to reach out to my office. I am always happy to help. The next thing is that the travel ban is gone. So if you are from any of the countries that you see on the screen right now, you are no longer banned from coming to the US, applying for family members to come to the US. Like, you can apply for your family. You can come to the US, okay? So immigrant visas to these countries are now back open. So do not delay, okay? If you held off on applying because of the ban, this is the time. This is the time, okay? Just start the process. Deportations are on hold. So that means if you are in immigration court, if you already have an order of deportation or removal, it's not going to actively remove you from the US for at least the next 100 days. Okay, so that's something to keep in mind. If you just finished your case or your case has been over for a while, just know that you are not going to be removed anytime soon. Hopefully we can get these bills passed that will hopefully lead to you being able to qualify for something so that we can make sure you stay in the US. That's something to look forward to. And then prosecutorial discretion is back, which means that if you go for an interview with USCIS, they will not be able to just put you in immigration court without you meeting certain requirements. So these requirements is that you have an aggravated felony, you have some sort of terrorism ties, or you just came into the US. So recent entrance into the US is going to have a harder time avoiding immigration court than someone that has been here for 5-10 years, okay? And then the bill that I keep talking about will hopefully create a roadmap to citizenship for undocumented individuals. That means if you're undocumented, you can apply for temporary status with the option of having a work permit for 5 years. So once you have that for 5 years, then you can apply for a green card. This is going to be a game changer if Congress can get this passed. It will make so many people's lives better. And I'm excited because this is why I do this. This is why I come into work every day, is to help people make their American dreams come true. And this is something that will definitely do that. So, like I said before, it's great that we have this new administration. They have been doing work, and it's only the first full day of them being in office. And we just have to really push Congress to make sure that they not only look at the bill, but pass it. Okay, so we can't let up. Now I'm going to answer some questions. Let's see. Can a 10-year green card holder file for his spouse and mother? So a green card holder can only file for their spouse and their unmarried children. So unfortunately, they cannot file for a mother until they become a citizen. So I hope that answers your question. Let's see. Farida is asking, can I file for withholding of removal now because I'm 3 years late for applying for asylum? So if you are, again, I can't really give you any legal advice as to whether you qualify or not. However, if someone is in removal proceedings, so someone is in immigration court and they no longer qualify for asylum because they missed the 1-year deadline, they have the option of showing that they qualify for removal of withholding of removal. Again, that's only possible if someone is already in immigration court. It's not something you apply for outside of immigration court. Okay. So Leona is asking, hi Lily, hi. I will be calling you tomorrow. Oh, okay. That doesn't need to be up there. Okay. Yes, feel free to call me if you have any questions, if you want to see if you qualify, if you want to start getting ready for any of these things that are coming up. This is the time to start basically preparing yourself, making sure that you have documents, because sometimes, depending on where you're from, I know I'm from Nigeria, so sometimes getting documents from over there is, it can take time. So let's make sure that we have, the documents that we would need if anything opens up and if these bills are passed quickly, that we are able to basically get you started and get you filing. So again, I am very excited, if you can't tell, about the new changes, about what's coming up, and I will continue to update you because this is, like I said, this is only the first full day of this administration, and there has to be more coming. Okay, based on what they're telling us, there's more coming, and and I will just keep on top of it and make sure that you get the information as quickly as possible. Okay, so can a person with a 10-year green card travel out of the US as long as they don't have any so typically, if you have a green card, you can travel. There are limits on how long you can be outside of the US. Only US citizens are allowed to be outside of the US for over a year without applying for anything else. So it's really important that before you leave, you consult a lawyer just to make sure that there's nothing that's going to affect you being able to come back. However, if you're just doing like a 1-week trip and you don't have any criminal history or anything like that that will affect your ability to come back in, yes, a green card holder is allowed to travel outside of the US. It's just wherever you're going might need you to apply for a visa for it. So just keep that in mind. Emmanuel is asking, will F1 students benefit from the pathway to citizenship? So the pathway to citizenship is really for undocumented individuals. So if the student is still in status, they will not be considered undocumented. So therefore, it wouldn't apply to them. But if the person, let's say, came in as an F1 student but has been out of status, then yes, this should apply to them once we get it passed through Congress. That's the main thing. Okay. So again, if you want to see if you qualify for the Liberian Green Card Act, if you're ready to start filing for your family member that's outside of the US that was subject to the travel ban and is no longer subject to the travel ban, feel free to reach out to me for a consultation, and we will basically go over your case in detail and see what your next steps are going to be to make sure that either you or your family member get a green card in the US. Okay. And as always, I will keep you updated on all the new things happening because there is a lot happening. And as always, if you have questions, put them in the comments and I will be responding to your questions in the comments as well. So even if you're watching this on the playback, please feel free to ask questions. There is a lot in here. Feel free to share this with your community because, again, there is a lot in here that will benefit them. And if you are not already following my page, which is Lily Legal, feel free to do that because, again, I will be constantly updating everyone on the changes and on the new and exciting things that are going to be happening in immigration laws and how you can benefit from it. Okay, so again, I'm Lillian Chukura. I'm the immigration lawyer and owner of Lily Legal, and I am so happy that you're here and that I'm able to share this information with you. Thank you and have a great rest of your day and great rest of your week. Bye.